Section 1. A legacy etched in law. The Canada Revenue Agency wields significant power. It shapes the economic landscape of the nation, yet its policies are not neutral. They are etched with the legacy of colonialism. This legacy has a profound impact on Indigenous communities and individuals with disabilities. This essay will delve into the CRA's practices, exposing how they perpetuate historical injustices. We will examine the historical context, legal obligations, and personal stories that illuminate this pressing issue. The history of Canada is one marked by the displacement and dispossession of Indigenous peoples. This history continues to shape the present. Understanding this context is crucial to comprehending the impact of the CRA's policies. We must move beyond surface-level analyses and confront the deeply rooted systemic issues at play. Only then can we begin to envision a future grounded in justice and equity.
Section 2. The Shadow of the Indian Act. The Indian Act, a cornerstone of Canadian colonialism, casts a long shadow on the lives of Indigenous peoples. Enacted in 1876, this act aimed to control and assimilate Indigenous populations. It imposed a system of governance, land management, and social control that undermined Indigenous self-determination. The legacy of this act reverberates today, influencing the relationship between Indigenous communities and the Canadian state, including the CRA. The Indian Act's impact extends to taxation, creating complexities and inequities for Indigenous individuals and businesses. For example, the Act's provisions on taxation on reserves have been subject to ongoing debate and legal challenges. The CRA's interpretation and enforcement of these provisions have significant implications for the economic well-being of Indigenous communities. Understanding the historical and legal nuances of the Indian Act is essential to grasping the complexities of the CRA's policies and their impact on Indigenous peoples.
Section 3. Unequal burdens, taxation, and Indigenous communities. The CRA's tax policies, while ostensibly neutral, often place a disproportionate burden on Indigenous communities. This disparity stems from historical injustices and systemic barriers that continue to disadvantage Indigenous peoples. For instance, the legacy of residential schools and forced displacement has resulted in intergenerational trauma and economic marginalization. These factors directly impact the ability of Indigenous communities to thrive economically and navigate the complexities of the tax system. Moreover, the CRA's approach to taxing Indigenous businesses and economic activities on reserves has been criticized for lacking cultural sensitivity and economic understanding. The unique challenges faced by Indigenous entrepreneurs, such as limited access to capital and infrastructure, are often overlooked. This lack of recognition perpetuates a cycle of economic disadvantage. It is imperative that the CRA adopts a more equitable and culturally sensitive approach to taxation that recognizes the distinct needs and realities of Indigenous communities.
Section 4. Disability and dispossession. Seizing income, severing lifelines. The CRA's practices extend beyond Indigenous communities, impacting individuals with disabilities as well. A particularly egregious practice is the seizure of disability income. This practice reflects a fundamental misunderstanding of disability and perpetuates economic hardship for some of the most vulnerable members of society. When the CRA seizes disability benefits, it effectively denies individuals with disabilities the financial support they need to live with dignity and independence. This practice often stems from bureaucratic errors or misunderstandings. For instance, individuals may be wrongly assessed as ineligible for benefits or accused of fraud without proper investigation. The consequences of these errors can be devastating. Individuals with disabilities may lose access to essential medication, assistive devices, or housing. The seizure of disability income is not only morally reprehensible, but also a violation of the rights of individuals with disabilities as enshrined in the Canadian Charter of Rights and Freedoms.
Section 5. A Charter of Rights, yet rights denied. The Canadian Charter of Rights and Freedoms guarantees equal protection and benefit of the law to all Canadians, regardless of race, ethnicity, or disability. Yet, the CRA's policies and practices often fall short of upholding these fundamental rights. The disproportionate impact of its policies on Indigenous communities and individuals with disabilities raises serious concerns about systemic discrimination within the agency. Furthermore, Canada is a signatory to international human rights agreements that obligate the government to protect the rights of Indigenous peoples and individuals with disabilities. The UN Declaration on the Rights of Indigenous Peoples, for example, recognizes the right of Indigenous peoples to self-determination and economic development. Similarly, the UN Convention on the Rights of Persons with Disabilities emphasizes the need for states to ensure the full and effective participation of individuals with disabilities in society, including economic life. The CRA's practices must be brought into alignment with these international obligations.
Section 6. Voices from the Margins, Stories of Struggle and Resilience. The impact of the CRA's policies is not merely theoretical. It translates into real-life struggles for individuals and communities across Canada. Consider the story of Sarah, a single mother from a remote First Nation community. Sarah relies on social assistance to support her 2 young children. Due to a bureaucratic error, the CRA claimed she owed thousands of dollars in back taxes. Despite providing evidence to the contrary, Sarah faced constant harassment from CRA agents, causing her immense stress and anxiety. Her story is not unique. Countless individuals and families have been caught in the CRA's web of injustice, their voices often unheard, and their struggles unseen. These stories underscore the urgent need for reform. When the CRA targets individuals and communities already facing systemic barriers, it deepens existing inequalities and perpetuates a cycle of poverty and disadvantage.
It is imperative that we listen to the voices of those most affected by these policies and amplify their calls for justice. Their experiences must inform policy changes and hold the CRA accountable for its actions. Section 7. Towards a Just Future, Reclaiming Economic Justice. The CRA's policies, rooted in a legacy of colonialism, perpetuate economic injustice for Indigenous communities and individuals with disabilities. This is not just a matter of tax law, it is a matter of human rights and social justice. We must move beyond simply acknowledging these injustices and take concrete steps towards dismantling the systems that perpetuate them. The path forward requires a multifaceted approach. First and foremost, the CRA must undergo a process of decolonization and anti-racism training. This process should involve meaningful consultation with Indigenous communities and organizations representing individuals with disabilities. Their expertise and lived experiences must be central to the development of equitable policies. Second, the CRA must be held accountable for its actions. This includes establishing independent oversight mechanisms to investigate complaints of discrimination and abuse of power. Finally, we must all become advocates for change. Support organizations working to advance economic justice for Indigenous communities and individuals with disabilities. Educate yourself and others about these issues. Together, we can create a future where everyone has the opportunity to thrive.